sort of catch in on the preload. And you know, first of all, this is Bob Luz from the Massachusetts Restaurant Association. Appreciate everybody being here today, taking the time. We know, obviously, it's a lot to be said that there's a lot on everybody's plate right now. This is the third in a series of webinars trying to get people ready and focused and having the tools to reopen. Started the first one on with Lisa Berger, sort of in terms of safety, sanitation, disinfection, making sure we got that whole side of the basis down. Second one with Dr. Muller, Chris Muller, was focused sort of on the operational aspects today as we move forward. And then this afternoon, we're working with Amy Carlin on, you know, sort of the legal side of our workforce as we kind of go through this. And, you know, it's all, you know, workforce is always a challenge to make sure that we're staying within the yellow lines. And now we've thrown a new partner into that called COVID-19. And so we did ask Amy to spend some time with us. She's well known for those of us in the Restaurant Association here. Amy's an attorney and partner with the great Boston law firm of Morgan, Brown & Joy. Her law practice is focused on employment law and obviously counseling as well. She plays in a really important role, I think, in terms of being a daily resource on legal topics relating to, you know, really every aspect of the employer-employee relationship. And her advice is applicable across all industries, but her clients tend to come from retail, wellness, fitness, and technology industries to a little bit. We like to think that there's a lot of it that comes from the restaurant and food services side. And I think that's because she's one of ours. Amy has worked in our industry before in many different roles. And as such, I think she can bring a unique viewpoint to the owners and operators in the association and really be able to talk to them in their language. She's been a frequent speaker on legal compliance in terms of employment. She regularly trains all of her clients and managers and staff on harassment, discrimination, prevention, how to manage employees with disabilities, all those other great sort of, or not great, but HR world things. And again, now we've asked her to kind of take on this new COVID-19 preparation. So with that, I thank Amy for taking the time to be with us today. I'm going to turn it over to you, Amy, and we're off and running. Thanks.
Thank you so much, Bob. I can't tell you how much I appreciate the Massachusetts Restaurant Association's invitation to speak to all of you today. And I really want to thank the MRA and all the folks, Bob, Carrie, Steve, and Renee. You know, I think I don't speak for myself when I say that, only for myself, that is, you know, when I say what an incredible resource and source of support you have been during this period of time. You know, I'm sort of, you know, connected to a lot of different communities. And I have to say that this community is so impressive in the way that it just came together and supported one another and got each other the information and the advocacy that the industry needs. And I think that, you know, MRA, your leadership is to be commended for that. So thank you so much for all you've done and continue to do. So as Bob said, my name is Amy Carlin. For those of you who have not met me before, I'm an employment lawyer. I deal only in employment and labor matters. I do counseling of clients, I do training, as Bob indicated, and I also litigate. So if a client of mine is sued, which I try to prevent, obviously, and that's why I work hard with my clients in counseling and training so that we don't get to that point. But if my client happens to be sued, then I can defend them as well and give them advice about how to manage the litigation and hopefully get out of it without, with fewest scars possible. So like I said, I'm happy and honored to be with you today. I feel very strongly and passionately about the restaurant business. I worked, as Bob said, I worked in the restaurant business before I went to law school and got a huge amount of experience. Opened up a restaurant as a server, was a bartender, roving office manager to GMs, went through all the back of the house and front of the house training when I became a corporate training specialist. And I really feel, to put it plainly, that you're my people. So it's really great for me to be here today with you in community with you all, and to be able to hopefully offer you information that you find useful going forward. And a brief shout out to my brother. I dragged my brother into this industry when I got passionate about it many years ago. I'm not going to say how many. And my brother is still in it. He's a bartender. And so he's joined us here today too. And I've been following, obviously his struggle along with, the rest of this industry as we make our way through. We're all being tested. And I think that it's, like I said, it's been great to see how strong and how much this industry has rallied. All right, without further ado, let's get into
Amy, can I just interrupt you for one? Amy, can I interrupt
sure.
you for 1 second before you begin? Hi, everyone. Just want to let you know to please utilize the Q&A function on your toggle bar down below. That allows us to keep track of questions coming in. And as we have natural breaks in Amy's presentation, we will interrupt for questions as they come in. So please use the Q&A function, not the chat. It's harder to follow from our behind the scenes end. Thank you.
Thanks, Steve. Yes, Q&A, not chat. Okay. Oops. Sorry, trying to move my. Okay. My slides are working, I believe. Okay, so a quick overview of the things that I'm going to touch on today. Basically, just a summary reopening plan. I know, many of you are already open and at some capacity, whether it be carry out, delivery, etc. But in terms of phasing into more brick and mortar application, I'm going to just touch on what the state's guidance is at this point. Of course, everything is subject to change. I should say that as a huge disclaimer. Everything is changing every day. So this is where we are right now. But as you know, things will continue to evolve. So also, we're going to talk about returning employees to work, which I really have to say is the bulk of the counseling work that I'm doing right now pertains to getting your employees back and the different permutations of what that looks like and how to do it well and lawfully. Common reasons employees are giving for not coming into work, how to respond to those reasons when your employee tells you that they're not ready to come to work or for other various reasons, whether and how to screen and test employees before returning, when and how to return employees to work if they've been exposed, what to do with a positive case in the workplace of COVID. And we'll deal with a few other common questions and considerations. And of course, I'm happy, as Steve indicated, to take your questions throughout. I promise you, if I do not have the answer to your question, because sometimes I do not know the answer, I promise to be able to get it to you. And if there is an answer, and there may just not be one, which is what is unique about this situation, I have to say. So just reopening plans statewide, you probably are all familiar with this, Governor Baker's executive order. There's really three components to the reopening guidance that the state has provided at this point, and it involves mandatory safety workplace standards. These are the standards that you're going to have in place relating to safety. So what we're talking about here is hygiene, hand washing stations, soap, all of these things that are going to go into disinfectants that you need to have in the workplace, and what standards and protocols the state is requiring you to have. These are, the link to these in more detail is on the state's website. Obviously, it's on my firm's website as well, and I can get you that information. The other thing that the state is requiring is a self-certification. So for those of you with locations in other states, you may be familiar by now, Connecticut, Rhode Island, New Hampshire, as well as beyond, every state is different in terms of what it's requiring. New Hampshire, for example, I've been working with some clients there. The certification requirements in terms of bringing your business back up to running capacity are quite specific, as in you need to take your employee's temperature, all right? In Massachusetts, it's not quite that specific. There are general guidelines that the state is requiring you to self-certify. There is a template that the state is providing so that you can check off that you have all these protocols and in place. But again, it's vaguer and not as specific as some other states. So I've been working with some clients to sort of tailor that self-certification to their business. And that's certainly something that we can discuss more. So this control plan that I referenced in this slide is the actual template that the state has. There's the other couple things that the state is requiring for you to post a compliance attestation. Oh my gosh, okay. And so you need to post that in your workplace. And then there are other various signs. And of course, these are all available from the state. We have them on our website too. And then of course, Governor Baker has a whole set of industry specific rules. Of course, we're all waiting the restaurant industry specific rules, anxiously waiting. Those have not been promulgated yet, but there are office spaces and other various business that have, the businesses that have been allowed to open to date. Okay, so let's get into the nub of it, which is, getting your employees back to work, whether you've been operating or whether you're just you've been shut down, and you're thinking about, if you've been shut down, you're thinking about how do I sort of phase in employees to get back to a space where I'm doing some manner of business, whatever that looks like for you. And like I said, those are evolving. Or if you've been operating, you might be considering, of course, what's going to happen if I am allowed to reopen in in some capacity. How do I get these employees back in? And you're not necessarily going to bring back your entire staff, all at once. So those are the considerations that you have to think about and plan. I was on this morning's webinar for some period of time, and I thought Chris did a great job about talking about planning and how planning is everything, and also this piece about communicating, right? Even if I love over communications, because in my world, the problems that I see employers get into is when there haven't been communications to employees. So even when you don't know the answers or what the actual, final answers are going to be, opening the lines and the channels of communication to your employees, I think really would do you well in this circumstance. So, when you're deciding about who to bring back, and you make the decisions based on legitimate business considerations, right? Who you need, when, sort of planning, how many you need, back of the house, what are you going to do for front, who's going to answer the phones, those kinds of things. Think about that, and depending on the size of your workforce, you want to make sure that if you're returning some people earlier than others, that you're not disparately impacting one certain protected class, right? So that's another consideration to think about. And again, communication, as Chris said this morning, is critical. In terms of my colleagues and I and all of the counseling, that we've been doing in the last, month or so, as there's been a gear up about this reopening phase, we've encountered a bunch of common responses from employees when they're contacted and being asked to return to work. So I thought it would be helpful to go through some of those more common responses and sort of talk through what some good responses are from you, the employer, in terms of what's legally required and some practical considerations. All right, so one of them is I don't want to come back. I'm making more money in unemployment, which as we all know, with this additional money that's been available from the federal government, that could be the case for some of your employees, obviously not all. And the issue here is if you have work that you're offering your employee and your employee says no and declines and says, I don't want that work, I want to stay out. The question is, what can you do with that employee? If that's all it is, if they're just saying, I'm making more money in unemployment, don't want to come back, you can say, well, look, your job's available. I'm going to have to give it to someone else. You can certainly reapply when you become ready, but we're considering it a resignation if you don't return, right? So that is what's sort of available in terms of a response for that. And then we have a number of employees who have indicated to their employer, no, I don't want to come back because I'm scared. I want to ride this out. I want to see how it, how it sort of shapes up, and I don't want to return. And so the response here is, again, if we're just dealing with what I call garden variety fear, right? It's not based on any medical condition. It's not diagnosed, anxiety disorder that's undercutting it, but it's really, I'm just too afraid. I prefer not to work. Again, it's a similar issue than the issue with unemployment, right? And, in terms of if the employee, this is another question, will the employee be eligible for unemployment if they decline to return to work? And I would say, typically no, right? Because the issue for unemployment is you need to be out of work, unable to work because of COVID related reasons. And one of those reasons is your employer doesn't have work for you, right? Either you're shut down or you don't have enough work to give to this employee. So, so technically, no, the employee would not still be eligible to collect unemployment in either of these two cases, the making more money on unemployment, ironically, and the I'm too scared to come in. So the too scared to come in, there may be employees who would be able to collect unemployment, continue collecting unemployment because it's a reasonable fear standard. So if the employee says, I didn't want to go back because of reasonable fear, they may still be eligible. But so here's where we get into the trickier issues, which is I don't want to come in because I live with someone, there's someone in my household who is higher risk, or I don't want to come in because I'm higher risk. And so, what do you do as an employer with those individuals? Now, so here's where, there are legal considerations in terms of what you can do. For the individuals who say, I don't want to come in because I live with someone who's high risk, you have to step back and sort of look at where you are as an employer. If you are an employer who is subject to the new federal leave laws, right? What we call FCRA, Families First Coronavirus Response Act, that came out of the CARES Act, and you are an employer who has 500 or fewer employees. If someone is saying that they can't come in because they need to care for this person who is in their household and high risk, then that may be something that that potentially opens up eligibility for that paid leave, right? Otherwise, if you're not covered by, FCRA, if there's no doctor's note involved, no one's bringing in a doctor's note, that says that they, I need to stay at home, then again, it's talk to the employee and figure out what's going to work. I mean, the overarching thing and overarching theme that I have been talking to employers about during this period of time, and what the CDC says, what the EEOC says, all of the agencies that have skin in the game on this one, they're all urging employers to be as flexible as possible, right? And I know that for some of us, we're at the end of our rope, and it's really difficult, to be patient and flexible. But that is what that's what the agencies are urging, and that is what I'm talking to employers about. How can we be flexible here? If you have someone who doesn't want to come in, there's no real legally binding reason to allow them to remain out on leave per se. What can you do for them? Can you say, all right, let's why don't you stay out for another couple weeks? I'll touch base with you again, and we'll see how it is in a couple weeks. If you can do that, great. If you can't, then, saying, look, I need to move on, but let's keep in touch and let's see if we can get you back, when you're ready or more comfortable. So the issue of I don't want to come in because I myself am high risk, that again requires some flexibility. From a legal perspective, again, the question is, are you required to give them some leave under FCRA? FCRA has paid sick leave, 2 weeks of paid sick, for which you're entitled to a tax credit, but 2 weeks of paid sick for employees who can't come in due to a sick-related reason. And I call those sick-related reasons are, I'm quarantined due to COVID, I'm under an order from my doctor to stay at home because of COVID. And so these, this, I don't want to come in because I'm high risk. Do they have a doctor's note that says they need to stay out of work? They're likely going to be eligible, right, for the paid sick, for those 2 weeks paid sick, okay? I can't come in because I still don't have childcare. Now again, this would fall under the guise of FCRA, right? If you're eligible, if you're an employer who is covered by FCRA, 500 employees or fewer, and someone says this to you, then they could be eligible for the 12 weeks of leave that law provides for individuals who can't come in because they need to care for a child, whose school is closed or whose daycare is closed, right? Their child care is cut off. So, so those are, some of the lenses through which you should be looking at these requests. Obviously, I mean, as many, clients as I have who have employees that have encountered this, I find myself talking through these issues over and over again with them because each one has, is sometimes, brings a unique point to it. And like I said, flexibility is the key here, and really listening and figuring out what are my legal obligations. In other words, can I say to them, well, sorry, I can't accommodate you here. We need to consider this a resignation. We need to part ways. Or are you required under law to give them some kind of leave, right? And so FCRA is one. The other type of leave you may be required to give under law would be a leave that would accommodate a medical condition, okay? And that's under the ADA, our state law, Chapter 151B, disability discrimination laws. So when anyone says to you, I can't come in because I have some kind of medical issue, including COVID, so that also gives rise to, under our disability discrimination laws, your obligation as an employer to engage with them and figure out whether or not you can provide them with some kind of leave. If none of those other leaves apply, obviously the statutory, the law leaves that I was just discussing, okay? So I know, let's take a deep breath.
Amy, actually, this is a great place. This is a great place for you to catch breath.
I'm taking a deep breath because I know this is a lot to put out there.
Why don't you take a deep breath? And a number of questions have come in the last 10 minutes or so. So let's filter through some of those. Some of them are specific. Some of them about or could be hypothetical. And the first question goes back a couple slides. Does the attestation sign need to be placed for consumers to see as well as staff from the governor's reopen guidance?
That's a good question. Okay, I can't not know the answer to the first question, but I believe it does. I don't know the answer to.
I believe it does need to be displayed to both.
I think it does too. I think it needs to be displayed.
Employees.
Yes, right. So that anyone from the public coming in knows that you're in compliance. It's not just your staff. Yeah, I think you're right about that. But we can confirm. Yeah.
Correct.
Steve, what would I do without you?
If an employee left and they're not coming back, do we need it in writing so that it's considered a resignation?
It's always better to have it in writing. Always, if you can get it by email or ask them, to write a note, that's good. But it's not absolutely necessary. I mean, if that employee, the question is for what purpose, right? And so if you're worried about unemployment or that employee trying to continue to collect unemployment, when you have offered them work and they've declined, you can, your report to, the DUA is going to be your report, right? You're attesting that this is the reason that the employee gave. And you're unlikely to be required to submit anything in writing unless, the employee contests or disputes, right? So, of course, I'm an employment lawyer. My answer is always going to be, get it in writing if you can. But, sometimes it's not always possible, right? So.
And the other thing I would add to that is, and this is not a PPP webinar, but if you're going for PPP forgiveness, you're going to want to have those returning employees acknowledging that they're not coming back so that you don't get held responsible for loan forgiveness on that one.
Great, yes, great point.
Couple questions on high-risk employees. What if you have a high-risk employee that wants to come back and you're not comfortable with them coming back?
Good, you anticipated future points in my presentation. So here's my thing about that. I know this business too, in particular, I feel like has a higher quotient of caring individuals who populate this particular industry, and so than others. And I know this is being recorded, so I have to be careful about what I say in terms of my favoritism. But look, your employee, you have to operate from the perspective of your employee is an adult, even if sometimes they're not acting like one, but your employee is an adult and they can take care of themselves, okay? And, you may have worries, you may have concerns. So this is how this issue comes up for me. And this is the question that I've gotten. Should I reach out to my high-risk employees and say, are you comfortable coming in? What should you stay out on continued leave? Is this something that, we can provide for you? And my answer to that is, you don't necessarily know who is high risk on your staff. Sure, there are people that you can identify, yes, this person is definitively high risk, but there are others on your staff that may be high risk that you're not aware of, right? And so you don't want to get yourself in a position where you're treating people differently because of their membership in a protected class, right? Because that's discriminatory. So my answer there would be, if you want to protect your high-risk employees, right, you want to reach out to all of your employees and you want to say to all of them, look, you have a high risk. If you're high risk and you want to talk about it, you need to come and talk to us because we want to work with you, right? And that would go to all employees, right? I don't want you singling out, a particular group that you think are more high risk, such as, your 65 and olders, for example, or your pregnant employees or, something like that. So I guess, that's what you sort of have to think about, whether or not you're willing to say, you know what, look, I'll let people identify with me if they're not comfortable coming back, and have them make the decision, because you're not required to make that decision, as an employer. I want to make that clear. But if you're the employer who wants to say, you know what, I want to know who in my staff is particularly high risk and who has needs and who might want to talk about it, I'm gonna send out something to everyone saying, look, come forward and talk to me. I would do that, right? So either way is good, but you need to choose, which way you want to go. I'm not a fan of picking, okay, this one particular person I know is high risk, so I'm going to treat them differently, if that makes sense.
Yes, it does. Would a pregnant server be considered high risk?
Yes. Yes. Yeah, pregnant employees are in the high risk category. It's pregnancy, individuals 65 and over, health conditions, chronic health conditions. And that's why I say we don't always know, right? Which employees fall in that high risk category.
All right, moving on. We'll take a couple more, and then I'll let you get back to your presentation, and then we'll
Sure.
take the rest at the end.
Yeah.
But we do have a number of questions that have come in on the last section. So if an employee is awaiting childcare to become available, are they still allowed to collect?
So what I take from that question is if they're home. So the criteria, I guess, I'll start from this perspective. The criteria is that you need to be unable to work and telework for that matter. So if, depending on what kind of employee you're talking about, I know, there's not a lot you can do from home, but some things in this industry you could, especially as you're, ramping up rather. So if an employee is unable to work because they need to take care of a child due to school closure or child care, they're eligible for that leave, right? And of course you're covered by FCRA. So if they have child care and they're not required to care for their child, then they're not eligible. So I'm a little confused by the question in terms of waiting. If they're home and they need to take care of their kids, they're waiting for childcare to reopen to be eligible. Then yes, they're entitled to that leave while they wait. Yep.
Okay.
Now I want to say one thing about FCRA, Steve, before you go forward, and this might apply to some attendees, which is there is a small business exemption for FCRA. It's 50 employees or fewer. And there's specific criteria that you need to sign off on. A major officer of the business needs to sign off on to get that exemption. You don't have to apply for it. You're just sort of making a self-assessment. But it's basically, if operations would come to a halt, is when you can avail yourself of that small business exemption. But I want to throw that out there in case anyone wanted to follow up and figure out whether or not they were exempt or they were encountering issues with the leave and wanted to figure out whether they could exempt themselves. Okay, sorry, Steve.
Oh, that's okay. What happens to an employee after the 2 weeks of the sick leave? Are they an employee or do they stay on unemployment? And if they continue to attest that they are scared or they are actually quarantined and they can't come in, do they get anything beyond the 2 weeks under the law?
Okay, so let's see. For them to be, first of all, for them to collect leave under FCRA, there needs to be work to be done. So they can't be on, you can't be on unemployment and collect on, under this leave. So presumably, so in the case where someone says, I can't, okay, you're asking me to come back to work. I can't come back to work because I don't have child care, they would be eligible for that leave, right? And so say, they can't come back to work because they're sick. And, for one of the COVID related reasons, they're quarantined, they're isolating due to a medical care provider, they have symptoms and they're seeking care from a medical provider. Those are the sick reasons. So the 2 weeks goes by and they can't return at that point, because what? Because they're still sick or for some other reason, they could still be eligible for the extended family medical leave if they have a child at home, right? Remember that goes on for 12 weeks, 12 more weeks in addition to the 2. But if there's no sick reason that they can't return and they just don't want to return, that's different, right? Because you, the employer, have offered work back and they're not asserting any kind of legally protected reason for them not being able to return. So they would likely not be eligible for unemployment at that point either. I'm not sure if I answered the question. That was a long question, but do you think
that was a complicated one?
Yeah.
Okay, let's pause on the questions and get back to the presentation, and then we can take some more questions at the end.
Okay, great. Thanks, Steve. Okay, so The other, as you're returning employees to work, we're working with CDC and state-specific guidelines with respect to what to do to ensure that your employees are well, right, when they return to the workplace. One of the big questions is, should I take the temperatures of my employees? The EEOC, which has, previously said, absolutely not, you're not allowed to do, medical exams of your employees, is now saying because of COVID, yes, this is permissible. One of the things that my clients are working on and toward are deciding what you want to do. Do you want to have your employee take it themselves at home and then attest that they did so when they show up to the workplace, and then it's not above 100.4 or lower, if you want to set it lower? Or do you want to take it in the workplace? And employers are doing both. So you have to decide sort of what you want to do in connection with that. If you do decide that you're going to do it at the workplace, you have to, of course, ensure confidentiality and train those individuals who are going to do it. And by training, it doesn't have to be a health professional. It can be someone that you just put in charge of it. And just training how to make sure that it's confidential, how to keep, the log, make sure that you're keeping accurate records, etc. Should I require my employees to attest to their wellness? So we are working with clients on wellness certifications, which I think are recommended. Many states are actually requiring specific wellness certifications and specific questions be asked of all returning employees. Massachusetts, not that specific, right? I talked about that a little bit before. The state is actually saying, you need to ensure that your employees are well enough to work, but they're not telling you how to do it, right? So we've come up with questions and a form that includes all of the CDC required, requirements. Have you been out of the country in the last 14 days? Have you traveled outside of Massachusetts for the last 14 days? It lists all of the symptoms. Have you experienced any of these symptoms in the last 24 hours? And can also list, have you experienced a temperature or fever over 100.4 in the last 24 hours? So the other consideration here is whether or not you want to do a one-time certification, have your employees sign off and say, look, this is what we're requiring for you to attest to before you come into work each day. And you need, by signing this form, which has all of the specific criteria, by signing this form once, you are attesting that every time you show up for work, you are okay to work, meaning that you have no symptoms, you don't have a fever, you haven't traveled outside in the last 14 days. When we first started out, it was sort of going 50-50 with employers on these. And I have to say, in terms of daily, having someone fill out a daily one versus a one-time, and I have to say now that I think the one-time approach is working better. It's more manageable. It provides less for managers and companies to deal with. And there's nothing that says it's not okay, right? And the employees are very clear about what the requirements are, and you have it in writing, you have it signed, and it's in their personnel file. Okay, so here's this is the criteria for employees who have either they say, yes, I have COVID-19, or I'm experiencing COVID-19 symptoms. This slide basically tells you what has to happen before this employee returns to work, right? And employees who have symptoms or a positive test, they are specifically meant to isolate and not return to work or go anywhere outside of their home unless these items under the symptom-based strategy have been fulfilled, meaning there's been at least 3 days since recovery, meaning no fever essentially. There's been an improvement in respiratory symptoms, and at least 10 days have elapsed since symptoms first occurred. Okay, so that's a symptom-based strategy. And then there's a test-based strategy where there's a resolution of fever, there's improvement. But the only thing different here is that you have negative results, and the CDC asked for 2 negative results of the FDA required test. So either one of those, symptom-based or test-based, is okay for you to say you employee can return to work after having COVID-19 or experiencing symptoms, right? This is a different situation when you have an employee who's been exposed to COVID-19, right? So the guidelines here, CDC and the Mass Department of Public Health, mandatory quarantine 14 days after exposure. Right now, CDC is defining exposure as spending more than 10 minutes within 6 feet of an individual who has COVID. Basically, we're getting a lot of questions, about exposure, especially if you have someone who is identified in the workplace. And I believe that one of my future slides is going to get to that. So, and then the other question that comes up is, what if, when I reopen or when I bring back more of my workforce, what do I do with a positive case of COVID? And hopefully none of you have had to deal with this yet if you have been operating, on a limited basis or a carry-out basis. But essentially, you need to really check in with what state and federal requirements are for cleaning and possible shutdown. You identify, and I've gotten calls from clients, look, I have a case, what do I do? Who do I communicate with? And the tricky issue here is, what employees, who do I need to communicate with in the workplace in terms of exposure? And, that essentially comes down to some reasonableness standard, because it can go really, depending on your workplace and what's going on there and who comes in and who comes out, we have to kind of really drill down and figure out what you need to do and what makes sense. It's not as easy sometimes as just saying, oh, well, that person was within 6 feet of that person, so I need to identify, I need to communicate with them. Obviously, you're not going to disclose. I mean, many times it's obvious, but you, the employer, should not disclose the name of the employee who was diagnosed with COVID. And then, of course, you have to communicate with the ill employee about return to work requirements, which goes back to the 2 slides that I just went through, right, in terms of when that employee is okay to return to work. Okay, so, other considerations. Here are some, questions that have come up a lot that I thought would be helpful to flag for folks. Can I request a doctor's note before an employee returns to work, right? So if someone was out because they were experiencing COVID-19 symptoms, the answer is yes. But the EEOC essentially says, sure, you can ask for a doctor's note, but the CDC says, yeah, you can ask, but you cannot require an employer, right? Because they don't want to tax the healthcare system, essentially. So if the employee says, look, comes back and says, look, I can't get one, but they've met all the criteria, right, that we just discussed in terms of time and absence of symptoms and fever-free, then we're saying employers don't require one before returning to work, right? And then, of course, for all of the other, paid sick, you can still require notes for Massachusetts paid sick to support ADA accommodation. I was talking about that before. And also certifications for if you are an employer who administers the FMLA, because you're 50 or more employees, regular FMLA now, not the extended FML that we're talking about under FCRA, then of course, you can ask for notes pursuant to administering that FMLA too, right? Okay, and then here's the question, Steve, that you asked. Someone had asked about high-risk employees. Can you offer them greater accommodations? Look, my guidance there is yes, but offer them to all high risk, right? Not just over 65. you remember confidentiality, and do I have to offer high risk based solely on their high risk? You know, no, you don't. But again, you need to be careful about if someone is just 65 or more without an underlying medical condition. Of course, you want to work with that employee. Is there any legal obligation for you to offer that individual an accommodation? No. But again, I take a step back, and this is not always possible depending on your circumstances, but I take a step back and say flexibility is the rule of the day, right? Just make sure as an employer, you figure out, and this goes into the planning, I think that Chris was talking about so poignantly, you know, earlier, you know, you can't overplan. And so thinking through what you're going to do and how you want to proceed with your employees, you know, in terms of identifying high risk and what you want to do with them is really critical, right? So just pay attention to that. And then the other question that I'm getting a lot is, should I have employees sign some kind of waiver or disclaimer before they return to work, you know, acknowledging that they're agreeing to, you know, to assume the risk, quote unquote. And, you know, I'd say generally no. You know, workers' comp, you know, covers, you know, negligence claims essentially, you know, brought by your worker for, you know, injuries and illnesses sustained at work. And so you can't waive those. So it's not going to absolve you. I don't think it does. It doesn't do much for you. And again, if you're going to, you know, put it out there to your employees that this is sort of a dangerous situation for them, I don't think that's a great idea, you know, either. It could be used as evidence against you down the line. All right, so that is the end of my planned presentation. Happy to entertain questions, Steve, in terms, you know, of time. I'm not sure how we're doing, but.
Sorry, I was muted. No, we have time for a couple questions that have additionally come in. The first one is, can an employee use additional mask sick time for COVID in addition to the 2 weeks provided under the additional federal law?
So yes, the answer is yes to that. So that 2 weeks provided by federal law, that cannot be used in conjunction with any state-specific sick leave or other sick leave that the employer provides, right? So that is absolutely, I'm so glad that someone asked that question, because that Massachusetts, you know, the max obviously is the 40 hours of paid sick. If people have that in their banks, they could use that as well, in addition to the 2 weeks provided by the federal law. Yeah.
Right. There's a number of forms that are being required, especially we're talking about daily employee health checks and all these different forms. How long do you recommend keeping these forms for?
So I would, so treat them as a personnel file record, right? With the understanding, and this is a good reminder for everyone, that health information should not be stored in an employee's personnel file. You know, it has to be stored separately and confidentially, but it is still considered part of the personnel file. So I would store it with the personnel file. And that is, I believe that you're required, I can't remember exactly what the amount of time is, you know, post definitively throughout the tenure of the employee's employment there. And I believe it's 3 years post, but you know, I can't remember the specific amount required by state right now.
Okay. A number of people have asked if you would mind sharing your slides in addition to the recorded webinar. Would you have any problems having the slides available along with the video recording?
No, not at all. I mean, I prefer, yeah, no, absolutely. I'll provide the slides. That's no problem. And one of the other things that I wanted to mention, Steve, is that please feel free to reach out to me by email. And I can, if you would like, we've posted all sorts of client alerts, and we're trying to get information out on employment-related, issues as they evolve here, during COVID-19. And so I'm happy to add you to our distribution list. And the other thing is that I've talked about some forms here today that I've been working on with clients. Please feel free to reach out to me, and I'm happy to connect with you and figure out, how I can help you if you want any of those forms. The other types of forms that we've been working on with clients are if employees need leave under the federal laws, the emergency paid sick or the extended FML, they need to attest to the reasons why they need the leave for you, the employee, the employer, to get the tax credit. And so we have some of those forms as well. And to Steve's point, Steve made a great point about the PPP too, and the fact that to the extent that an employee voluntarily resigns and your head count is going to be lower, and you don't want it to deminimize your ability to get maximum loan forgiveness, you'd want to keep a record of that too. So yeah, so feel free to connect with me individually. Happy to share the slides. And then there was one other thing. Oh yeah, so the other thing is OSHA too is something that I did not bring up. I wanted to bring up in terms of be careful about OSHA complaints as well. And that's why it's important to fulfill all of the mandatory safety requirements because we've been seeing an influx of OSHA complaints by employees. And mostly they relate to lack of communication and training around what is expected of employees in the workplace with respect to these new rules, hygiene, wearing masks, for example, all of that kind of thing. So that's, I think we had that in the back of my head, and I wanted to make sure I raised it before we ended.
I think we have time for 2 more questions, and I recognize that one of them could be their own independent webinar, so I'll leave that last. But the one question has to do with in the event of a positive case with an employee, do I now need to recommend a quarantine for all my employees that have been exposed to that employee that has a positive case? Same question, if I'm found to have a guest that has been diagnosed with COVID, do I then need to quarantine my employees for 14 days?
Okay, so let's take the employee first. So yeah, this is sort of what I was hinting at when I was talking about exposure and the 14-day quarantine requirement. And the fact that when an employee discloses to you that they have COVID, you, the employer, you then need to sort of retrace the employee's work steps, and figure out, you don't necessarily need to inform everyone. And again, we're talking, it depends on, what you're talking about in terms of where that employee works, right? Employee works behind the bar, right? And there are 3 barbacks and another bartender that worked with this employee on this shift definitively, right? There was enough contact and enough side-by-side interaction with those individuals. That's exposure. That's exposure with a capital E. The things that are more difficult to parse out is sort of exposure with a small e, which is, well, okay, the bartender briefly, went down to, the wine room and, walked by, the busser, but otherwise had no contact with that particular busser. Do I need to inform the busser? Those are the things that require, some thought. And do I really need to, like I said, the CDC is saying 6 feet, closer than 6 feet for more than 10 minutes. Right? So there are some people that, if they're just passed through or passed by, once or twice throughout the shift, probably not going to need to inform them. But then there's going to be a whole, some individuals who clearly need to be informed about that employee. So it's really a case by case, situation, and figuring out what exactly that employee and how they, where they were, where they worked, and how they interacted with others, during their work time. For the guest, again, I think that goes to trying to figure out as much information as possible in terms of, what that guest came into who that guest came into contact with. I think, it's not, these aren't easy sort of determinations to make, unfortunately. And I think we're going to learn a lot more as we go along in terms of guidance too, in particular with respect to, when restaurants are allowed to reopen and actually members of the public are able to interact, with employees. But for right now, my response is this is going to evolve. And for right now, I would say you have to do sort of an analysis about where, who that guest, came into contact with and who you actually need to communicate with about the exposure. And once you do, the ultimate, answer is once you do identify who's been exposed, right? So going back to my bartender and barback example, yes, those barbacks are out for 14 days.
Okay. And then as best as you can answer this, I know that this is an evolving issue both at the state and federal level. Could my business be held liable for an employee with a positive COVID-19 case or outbreak?
Yeah, I mean, the liability issues here are, are interesting. Like I said before, in terms of employees, seeking some kind of, judgment from an employer, workers' comp is the system for that. And there's a reason why, employers pay into it. And so that, what would go beyond workers' comp would be, intent, like gross negligence, right? Like recklessness. So if you as a business are complying with all of the, you have the control plan in place, and you're complying with all of the requisite safety protocols, you have someone, I wanted to mention this too, you have someone who's in charge of that and is in charge of, monitoring and making sure that they're being followed on a consistent basis, then I think you're in good shape in terms of defending against, something like that. But yeah, you're right, Steve. I think this is going to definitively evolve.
All right, that has us at about 56 minutes. I think today has been a very informative webinar, and I think we probably could have gone on for another 2 hours answering questions and specific employee-related issues as we navigate this. I want to thank everyone that has joined us today. You see Amy's contact information on the screen. We will be recording this webinar and posting it out to everyone. And again, we will have the slides available as well. Please do not hesitate to reach out to MRA or Amy directly with any questions that you have. And thank you everyone for attending today.
Thank you so much. Thanks, Steve. Thanks, MRA. Appreciate it. And I wish all of you my best. I really do. And please feel free to contact me with any other questions. Thanks.